Okay, this is, oh, wait a minute, we have to get on the record.
I apologize.
Okay, we're live and on the record. Ms. Al-Yassari, how are you today?
Good, Your Honor.
You can hear me okay, I assume?
Yes, ma'am.
Okay, this is People of the State of Michigan versus Bador Al-Yassari, docket number 19-220FC, and this is the time set for hearing on the defendant's motion for a stay. May I have appearances for the record, please?
Thank you. Good afternoon. Assistant Prosecutor Bill Carino on behalf of the people of the state of Michigan.
Good afternoon, Nicole Matusko on behalf of the people of the state of Michigan.
Andrew Abood on behalf of the defendant.
Carrie Kerber, also behalf of the defendant.
Thank you. And obviously, Ms. Al-Yassari is present. And Mr. Abood, this is your motion. You may go ahead.
Thank you, Your Honor. Our motion is one for a stay, and I will correct. In paragraph 9 of our motion, we cite to 7.209, and we incorrectly cited to, I think it's E1. It should have been E2. So the prosecutor correctly pointed out that what we said didn't say that. It should have been E2. I don't think there's a big dispute on the standard. I think in this particular case, the standard is low. The court would have to find that our motions were frivolous or without merit. There are 4 motions in particular out of 10. We have properly and I believe timely filed our motions for appeal. They all deal with the admissibility of evidence. And I can get into the merits of each one of those. And the only to the extent that I'm not trying to challenge your decision making in this hearing, I'm just suggesting that I think that those motions were not frivolous. And from reading the prosecutor's response, I don't like to put words in his mouth, but it doesn't appear that he's arguing that they were frivolous. One of his arguments is that we don't cite any direct case law, and I think the case law is certainly sparse on one issue, and I think for that reason it would make it to have some merit. Just addressing the 4 motions, and I'll address maybe the 2 easier ones, which the motion with regards to the violent crime and the reference to the violent crime team and the arrest, I think are certainly more discretionary within the court. The case law is probably more favorable to the prosecutor, but I think under a 403 analysis that there is merit to the motion, although the court's opinion and ruling is probably stronger there, but the standard is again one that it would have to be frivolous. The other 2 motions, I think, to me, seem to be for the defendant stronger. In particular, in the one case, in the one issue regarding her violation of her 5th Amendment and the representations made by the officer that it would essentially remain confidential or stay here. Obviously, the defendant was read her Miranda rights, and we aren't challenging that, but it is a question of, can an officer misrepresent the facts? And I think the law is clear on that, maybe as high as the United States Supreme Court, that they can lie to a defendant in order to establish a confession. But when it comes to the rights of a defendant, I think the case law is sparse on that. And clearly, if even though the defendant was read her Miranda rights and she properly gave a waiver, that waiver in my mind is continuing with each and every question. And when the officer made the statement that it'll remain confidential, that seems to be a conflict not only of her rights, which is problematic. And I think the case law is sparse on that, which means that our position, I don't think, can be frivolous. In regards to the seizure of the phone, I think that both in regards to the seizing of the phone and the search warrant. I think the search warrant, in my mind, in reviewing it, although the court disagrees, was weak. But I think that the basis of them seizing the phone and whether there was evidence of a crime, at the most they had that there was evidence of a relationship with a third party, and under those, that doesn't necessarily mean that it would be evidence of a crime. Maybe motive for somebody, but not evidence of a crime. So for those reasons, I think there is merit in the motions that we filed. We properly, I think, dotted all the I's and crossed all the T's, and we'd ask that the court grant our motion to stay.
Thank you. And Mr. Crino?
Thank you, Your Honor. The people have filed a written response, as was indicated by Mr. Aboud, and we would rely on our written response unless the court has specific questions you'd like us to address, please.
I don't, thank you.
Thank you.
Well, the court rule MCR 7.205 F3 provides basically that when I make a decision on admissibility of the evidence and either side files an interlocutory application for leave to appeal seeking to reverse that decision, the trial court is required to stay proceedings. There are, pardon me, 2 exceptions, and one is that if the evidence is clearly cumulative, no one claims here that the evidence is cumulative. The other is that an appeal is frivolous because legal precedent is clearly against the party's position. I think the prosecutor's point is well made, that this really, it doesn't turn on legal precedent, it turns more on factual findings that I made following the hearing that we had. That said, I would be tempted to call this an exception because it doesn't fit. I would be tempted to deny the stay because it doesn't fit under that second exception. But here's the real practicality of the matter. This is a high publicity case with hundreds of witnesses and mountains of physical evidence that the people intend to introduce. I know this because I presided over the first trial of the co-defendant. And we are in a situation right now where currently we can't even have more than 10 people in the courtroom at any one time. I don't know when that's going to change. And even if it changes, and it may change, given our current local administrative order that's been approved by the state court administrative office, and it may allow us to bring in jury panels, but not of the size that we would need for a life offense with high publicity. And there's no way we could keep the number of people in the courtroom or the jury assembly room or the entire courthouse at the levels that we would be required to keep them, which is based on our capacity and ability to keep people 6 feet apart. For a trial like this, there is absolutely no way. So what is the harm of granting a stay when we are going to be in an informal stay proceeding or stay situation anyway, because there's no reasonable way that we can balance this need for a trial against the need to protect the public and the public health. And I know there's no standard for that in this court rule, but this is a unique situation. And for those reasons, I'm willing to grant the stay because it allows the defendant to fully explore her appellate avenues while we're in a holding pattern anyway. And the stay will just ensure that she has a full opportunity to do that, which she may have had anyway. But again, there is no harm in granting a stay here when there's no practical way that we can proceed in the foreseeable future. So I am going to grant the defendant's request for a stay. And
Thank
I would
you.
add that she has filed the interlocutory appeal already, so that has been established under the court rule.
Thank you.
And you're welcome.
Okay, the hearing is over, Miss Alasari, and somebody will be out to see you. Thank you, Judge. We'll submit an order.